Hello friends, today we will be discussing different types of companies under the Companies Act 2013. So let's start. Before we discuss anything about different types of companies, let's understand that whenever you come across any of definitions in the Companies Act, or for that matter any other law, how you should read that Companies Act or that particular provision of the act. So let me tell you that whenever you come across any word, for example, in Companies Act, you come across private limited company. So you will have to first divide it into parts. So what is company, what is private limited? These two parts need to be bifurcated and then understood. So before understanding, you should know that there are two types of definition always in any of the act. So first is exhaustive definition and one is inclusive definition. So whenever you will read any of the definition in any of the act, you first find out whether it is exhaustive one or whether it is a inclusive one. So exhaustive definition is a definition which includes the words like means. So if you read the definition of company, it clearly says that company means a company registered under Companies Act 2013 or any other previous law. So there is no scope for further interpretation, for adding on any of the similar kind of points. You will have to stick to the definition itself because it is a exhaustive definition. Second type of definition is an inclusive definition. So if you read the definition of body corporate in Companies Act 2013, you will see that the definition starts with body corporate includes. So it is an inclusive definition. So whatever has been mentioned after the word includes, you can add up similar parts or similar kind of organizations in that particular definition. So we need to understand what kind of definition you are reading, and on that basis you will have to crystallize whether it is an exhaustive definition or whether it is an inclusive definition. In exhaustive definition, where there is a mention about means, you will have to stick to the definition. In inclusive definition, you can add up certain other type of things also in that definition and you can interpret it that way. Whenever you read a section of Companies Act, you will have to interpret a particular part of that part of that section on the basis of various sources. So whenever you are reading certain section of Companies Act, for example, you are reading section 188 of Companies Act and you come across words like arm's length. So from where you will get to know what is arm's length? So there are 6 main sources of any of the interpretation in Companies Act or for that matter any of the act. The first source of information about interpretation of a particular clause in a definition is the section itself. So for example, if you look at section 188, the arm's length has been defined in that section itself as a part of explanation. So 188 clearly defines arm's length. So you will find that you don't need to go anywhere. Once you read that particular explanation, because explanation will start like, for the purpose of this section, arm's length means so and so. So your search is over. So the first and foremost part of source of your information is the section itself. If that section is silent about what it means, then you will have to go to second source. The second source of information is usually the interpretation clause. The interpretation clause of any act, usually section 2 of any act will have this interpretation clause and it will provide you different definitions. So if section is silent, then forget about that source, go to the second source, which is the interpretation clause. That interpretation clause will have all the definitions and you will have to use the definition according to the section 2. So section 2 usually will start like, for the purpose of this act, the following means following. So you will have to undergo section 2. That is the second source. If your section is silent, if interpretation clause is silent, then you will have to go to the third source. The third source of information about any interpretation is General Clauses Act, because General Clauses Act clearly states that whenever in any central act if certain things are not defined, then general definitions will apply, and they have been mentioned in General Clauses Act, like definition of person. So you will have to find out the third source of information, that is General Clauses Act. After General Clauses Act, so if main section is silent, interpretation section is silent, General Clauses Act is silent, then the fourth section or the fourth source which you will go to is the dictionary. So you'll have to find out the dictionary meaning. Usually the Oxford Dictionary meaning is acceptable everywhere, so that will become your fourth source of information. If all these four are not very clear or available, or it is not up to the context, then you will have to go to the fifth source. The fifth source is decided case laws, and those are reported case laws. So any Supreme Court case which has defined a particular expression, like for example loan, it has been defined in a Supreme Court judgment, so you can borrow it if the first four parts or first four sources are not available. So that will be your fifth source of information whenever you are interpreting any provision of the law. And the last one, which is the rarest one, this you have to use it as an exception, is to borrow from other statutes. So in few of the cases it is mentioned that you can borrow it directly, because the first source, like for example section 188, it says that goods means goods as defined under Sale of Goods Act. So you can directly borrow it because it is coming under the first source of definition. But if it is not mentioned there, then you will have to follow all the 5 steps. So first is the section itself, second interpretation, third the General Clauses Act, fourth your dictionary, fifth judgment, and then the sixth is the other statutes. So you can borrow it from other statutes only if the first 5 are not available. So these are the basic fundamentals of interpretation of statutes, and I wanted to share this with you before we discuss anything about private limited company or public limited company or a company. So when we talk about company has been defined under section 2 subsection 20, which says that company means. So here the words used is means. So it is an exhaustive definition. You cannot add anything into this. So company means a company incorporated under the Act or under any previous company law. So presently the Act is Companies Act 2013. Any other previous law will include 1956 Act or any act which was prevalent in India before 1956 also. So all those companies which are registered under all old acts prevailing in India will be treated as a company for the purpose of Companies Act 2013. LLP will not be included in company because it is not company registered under Companies Act. So let us be very clear about Companies Act is applicable only to the companies incorporated. LLP Act is applicable only to the LLPs incorporated. So there is a clear-cut bifurcation about it. And LLPs, there is a provision in LLP Act that Ministry of Corporate Affairs can make certain provisions of Companies Act applicable to LLP, but that is through a notification. Otherwise, Companies Act is not applicable to LLPs. LLP Act is not applicable to Companies Act. So we'll go ahead. So now there are major two types of companies. One is company limited by shares, company limited by guarantee. And there can be a company limited by shares having limited by guarantee having share capital. So 3-4 types of companies. And also there is a concept called as company which is with an unlimited liability. So on the basis of liability, there are 4 types. One is with guarantee, one is with capital, one is with guarantee having capital, and fourth is unlimited company. Unlimited company usually is not incorporated because we always talk about private limited or public limited companies. Due to section 3A of Companies Act, when the number of members fall below the threshold of 2 or 7, and if it is not increased within 6 months, then that particular company becomes an unlimited company. So let's not get into the details of unlimited company, but usually the companies are limited by shares or limited by guarantee. Next is private limited and public limited companies. For general understanding, private limited company is a private in nature. It has got investment of very limited people. It has got restriction on transfer of shares, and it cannot go for a subscription of their securities outside to the outsider. So these are the three basic restrictions in case of private limited company. So if you look at the definition of private limited company, it clearly states that a private limited company is a company which restricts itself by its articles in three cases. There are three restrictions: restriction on transfer, restriction on number of members. So for example, for OPC it is one number of members, that is a maximum number of members, and for private limited company it is 200. So you can have maximum 200 members in a private limited company, and the articles restrict or prohibit the invitation from the public for subscription of any securities. For the purpose of understanding what is security, security has been defined in the Companies Act as securities means securities as defined under section 2H of Securities Contract Act. So we need to borrow that definition from Security Contract Act regulation. So SCRA. So we'll have to refer to SCRA, and SCRA will decide. So private limited company is very, very clear. Any company which is having three restrictions in articles will become a private limited company. Now the definition of public limited company, once it is very clear to you that what is private, the public limited company definition becomes very, very easy. Public limited company is a company which is not a private limited company. So any company which does not have these restrictions will become a public limited company. So public limited company will not have three restrictions: restriction on transfer, restriction on number of members, and restriction on inviting the subscription for various securities. So there is a difference between a private limited company and a public limited company. As per Companies Act 2013, the entire act talks about only these two types of companies when it comes to compliances. But the definition of public limited company gives a different thought process in the proviso. It says that when a company is a subsidiary, when a private limited company is a subsidiary of public limited company, it will be deemed to be a public company. So third type of company comes into picture because of this definition. So a private company which becomes a subsidiary of public limited company will be deemed to be a public limited company for the purpose of this act. And deemed has been defined in only dictionary, which says consider. It is not but treated as. So a private limited company is not a directly public limited company, but for the purpose of Companies Act, it is deemed to be a public limited company. So all sections will get applicable to that particular private limited company as if it is a public limited company. So we need to understand private company, public company, and deemed public company. So these are the three different types of companies which we are discussing right now. Third type of company which has been defined in Companies Act is listed company. So for the purpose of understanding the definition, it says that listed company means a company which has any of its securities listed on any recognized stock exchange. So we need to bifurcate this definition into three parts. One is a company. So listed company has to be a company. Second, any of its securities. So securities has been defined in SCRA Act. So you will have to borrow that definition. Any of the securities, if it is listed on any of the recognized stock exchange. So again, you will have to go to the definition of recognized stock exchange. So any security, if it is listed on any of the recognized stock exchange of any company, it will be treated as private limited company. So from 1st April 2014, when the company law started, this Companies Act 2013 started its implementation, till 31st March 2021, even a private limited company whose debentures are listed would be treated as listed company for the purpose of Companies Act. For LODR, all companies whose securities are listed is a listed company, but for Companies Act perspective, only those companies which has so there is an exemption. So a company whose only debentures are listed and equity is not listed, those are not treated as listed companies. So these are the three main important types of companies which we must understand. So I'm restricting myself to only these three. So we have understood how to interpret Companies Act or any other act. What are the 6 sources of understanding any provision of the act? Then we discuss 3 important aspects of private limited company, public limited company, and listed company. In the next video, we will definitely discuss what is holding company, what is subsidiary company, what is associate company, and then different types of companies under Companies Act, which includes one person company, Section 8 company, producer company, foreign company, which is a liaison office or a branch office of a foreign company, and the definitions of those companies. So thank you for watching this, and if you have any questions, you can post it, and subscribe to my channel for knowing the further videos and further updates. Thank you.